Greetings to everyone. This is Attorney Osmond Johnson, the counsel and representative for the Stellar Energy Group. We've had a lot of feedback of late as it regards the last 2 or 3 video posts that we've issued, and in particular requests for further information from the public concerning the May 22nd hearing before the Supreme Court. As I said at the time, I am very pleased by the progress that we've made thus far in our efforts against the Crown in this action. As it regards the hearing itself, it was convened before the Honourable Chief Justice of the Commonwealth, which again I am very encouraged to see, precisely because he is not only a preeminent jurist, but also the most senior member of our judiciary, and I think someone who is well placed to adjudicate on such matters of general public importance. At the hearing itself, counsel for the second and third defendants, which are the Attorney General and Ministry of Public Works respectively, erroneously suggested to the court that we were there before the court on a separate application, which had been filed seeking a strikeout of the plaintiff's application for discovery, and it was filed on June 28, 2019. The truth of the matter was that the parties were before the Honourable Supreme Court on the hearing of a separate application to strike out the cause of action in this matter, which was filed on November 7, 2016. Suffice it to say that I adequately corrected counsel on his error and set the record straight for the purposes of the proceedings. In any event, once that confusion was resolved, the court ordered that the Crown's application to strike out our application to seek discovery was to be dismissed forthwith, given that it was essentially a procedural error with 2 summonses before the court seeking essentially the same relief. That's unacceptable by any interpretation. Following that decision, the court ordered that the parties, if they wish, submit an affidavit in support of the application. The plaintiffs were given a deadline by June 10, 2020, which we of course intend to comply with, and the Crown, for its part, was given a deadline of June 26, 2020. As for the matter itself, it was adjourned to be heard between the 6th and 21st of July for a date to be confirmed closer to the time by the Honourable Supreme Court. It is unfortunate that we were unable to proceed further on the said hearing. As we have been throughout this process, this office was fully prepared to move ahead and dispose of the Crown's application seeking a strikeout of the cause of action. We feel that it is procedurally foul. It is also not commensurate with the rules of the Supreme Court on certain key aspects which we will raise at the hearing itself. And what it represents, in my humble view, is an abuse of the court's process and a collateral attack on the rights of the plaintiffs to seek the relief that they have done under the action itself. We are nonetheless very heartened and, as I've stated previously, encouraged to continue with our efforts by what we see as repeated missteps and errors made by counsel for the Crown, and indeed, as I have iterated to our viewing public on many occasions prior to today, our resolve is firm and steadfast, and it will remain so until these matters are brought to fruition. I don't think that I only speak from my own opinion when I say that these matters are ones which concern all of us, and to which all conscientious Bahamian citizens should have their focus trained upon. We hope to continue to have your support as we move forward, and we thank you for all of the time and effort that you, the public, have spent in following some of the content that we've released and in generally being a support network to what I think you all recognize are credible efforts that are being done for the better good of the wider public. And once again, I thank you, and I bid you all a very good day.